There we go.
3-second for books.
And so
I see the Netflix one and I see the 212 degrees.
Right here.
Okay, so I'm not the only one then.
Yeah.
I'm like, Missy, I do not know this
so
book.
if people who are not
Personal note.
if people who are not intending to speak to the whole group can mute, please. I can scroll through all 100 participants. First off, we would normally start with sharing a slide from our COVID data. I'm not going, people may have noticed already that Charlize is out this week. I'm not going to try and be admitting people and making people host and share my screen all at the same time. The good news I can tell you, our data is available on our website. And it changes, fortunately, recently, very little. Since last month, since actually the beginning of March, we have had only one additional person test positive for COVID-19, and that was one
Yes,
person.
I'd like to make an appointment for a pedicure.
That was, okay, well, that's one we're not handling here this month. So we've had only one additional person. That was a person in a natural home. And fortunately, that is the extent of our COVID report this month. We will have a presentation by Neha Patel from DDS with our general counsel's office, and Kara Vandenberg, who is with the Quality Trust for People with Disabilities. And they will be talking this month about supported decision-making. So I'm just going to turn it over now to them.
Thank you, Andy. I will say the primary presentation is really coming from Carrie, and I'm going to provide some commentary and answer questions and kind of run the slides while she's speaking. So let me get the slides up for everyone. Hopefully you'll be able to see them okay. Okay. Is that working?
Yes.
Yeah.
Great. All right, Carrie.
All right. Can you hear me okay?
Yes.
Okay, great. Hi, everyone. Good afternoon. As mentioned, my name is Carrie Vandenberg, and I'm a staff attorney at Quality Trust for Individuals with Disabilities. We can go to the next slide. So just a little quick background on us. So we are an independent nonprofit advocacy and monitoring organization that has been advancing the rights for DC residents with developmental disabilities since 2001. Our work through our monitoring, lay advocacy, and legal services is deeply rooted in promoting rights protection and advancing decision-making supports that maximize people's self-determination. In 2013, we created our Jenny Hatch Justice Project following a court victory on behalf of its namesake, who was a woman with Down syndrome. We represented her in getting her guardianship terminated in favor of supported decision-making, which is a less restrictive option. And so we're going to be talking about what supported decision-making is today.
And I'm sorry, Carrie, can you hold on 1 second?
Yeah, of course.
It may just be me. I'm not seeing the interpreter.
Oh, I'm seeing her.
You don't have your own space for that.
Yes.
And
Yep. She's,
you know, come see us when you do. Like the other day we have went out and her told me blacking. I'm like,
I can see her.
Oh, okay. Can
and you can't
we,
expect us to do that. It's just like, oh, you out here with something, I'm going to jail. Da, da, da.
Lydia, we can hear you speaking.
oh, thank you. You know what that was then. Okay, so I will assume that people who need to see the interpreter can.
I can see her, Andy. This is Jared.
Okay, okay, then please.
And now, can we go back to the second slide, please? Oh, you got it. Okay. All right. So the purpose of our Jenny Hatch Justice Project is to advance people with disabilities' right to make choices, which is the principal prerogative all people have to make their own decisions and direct their own lives to the maximum of their capabilities. Our Jenny Hatch Justice Project provides free legal assistance to qualifying DC residents who are in or at risk of overbroad or undue adult guardianship, or who want help implementing less restrictive options like supported decision-making. Next slide. So here's a list of today's topics that we're going to be going over today. So we'll be talking about the what, why, and how of supported decision-making. So talking about what supported decision-making is and what it is not, why supported decision-making is so important, and then we're going to discuss the hows of supported decision-making, including the toolbox of tools to use to advance supported decision-making. We'll provide an overview of the types of supported decision-making agreements that are available in DC and explain how to complete them, all while recognizing that supported decision-making is much more than just a piece of paper. Next slide. So what is supported decision-making? So I'll give you a legal definition of what it is based on DC's new law and legal literature, but we're going to humanize it first. So the best definitions come from people with disabilities themselves. So this is a picture of Ricardo and Donna, which many of you may know. They're DC residents who used to live in Forest Haven, a now closed institution. Ricardo said, "I can make my own decisions. When I lived in an institution, I wasn't allowed to make decisions. When I got out, I could move towards making my own decisions with the help I wanted." Donna said, "I can think for myself. We can do things for ourselves. We can talk for ourselves." Next slide. Supported decision-making starts with the idea that people with disabilities, including those that are age-related, can make their own decisions with the support they choose and want. They can get help by using friends, family members, professionals, and other people they trust to help understand the issues and choices, ask questions, receive explanations in language they understand, and then communicate those decisions to others. It's really what we're all doing every day. None of us make decisions in a vacuum without the support or advice of the people that we trust. The key with supported decision-making is to remember who is making the decision. Next slide. When we talk about this in the context of people with disabilities, it is that person with a disability, not his or her supporter, that makes the final decision when they are using supported decision-making. This can be contrasted with substitute decision-making, where someone else makes the decision, and shared decision-making, where a decision is made based on consensus. Next slide. And thanks to a law that went into effect in May 2018, supported decision-making is now specifically recognized in DC statute. And this is the definition here. But I still think Ricardo and Donna said it best. Next slide. And so now let's turn to the why of supported decision-making. Why are we talking about this? I can cite decades of studies that have linked self-determination or being an actor in one's own life to better life outcomes for people with disabilities and older adults, including greater integration and independence, better physical and psychological health, and better employment outcomes. But again, I think the best reasons for supported decision-making come from people with disabilities and their family members themselves. So here is a picture of Ryan. In 2016, Jenny Hatch Justice Project supported Ryan in becoming the first DC resident to have his guardianship terminated specifically in favor of supported decision-making. And that was before DC's supported decision-making agreement law was enacted. When he was going to be exiting out of special education, his parents got guardianship over him because they were told they had to in order for him to receive adult disability services. That wasn't true, but they didn't know that, and they wanted to support Ryan in achieving his dreams to be an entrepreneur. Eventually, they determined guardianship wasn't a good fit for their family. They came to the Jenny Hatch Justice Project for help, and we represented Ryan in getting his guardianship terminated. Ryan said, "Don't judge me before you know me." That is a powerful statement. Knowing the ins and outs of supported decision-making reminds us that what people can and cannot do is not predetermined by disability. Ryan is so much more than any diagnosis that he has. Herb, Ryan's father, also said it well. Ryan is a whole person. We want him to be whole. The decision process is part of being whole. If I try to force Ryan to do something, I am destroying his selfness and being whole. He is a whole person and he is making decisions, and I encourage him. Next slide. There is no one-size-fits-all method for supported decision-making. The key question is, what will it take to successfully support your loved one? It is critical that you work with the person and identify where help is needed in order to help support the person in making their own choices. Supporters do not make decisions for the person with a disability. Instead, they help them make or communicate their own decisions, such as where or with whom they want to live, what services, supports, or medical care they want to get, where they want to work, how they want to save or spend their money, and more. Supporters may also explain the choices they face in more easily understandable ways, ask questions for the person, help them gather information, or assist with the person's communication to others. Next slide. And so there are two big myths that I want to debunk today. The first myth being that supported decision-making isn't legally official. And of course, as we've already mentioned, that's incorrect. DC recently passed the Disability Services Reform Amendment Act, which formally recognizes supported decision-making as an option for adults with disabilities. It also created a statutory agreement form between the person and the supporters. And I want to emphasize here that a person doesn't have to formalize their supported decision-making arrangement to use supported decision-making informally. However, if a person does put the arrangement in writing, they should use the form. The form is a legal document that identifies someone you trust to make decisions for you in certain conditions. And the second myth is that people with certain kinds of disabilities don't have the capacity to use supported decision-making. And this is also untrue. We need to rethink how we define capacity. Capacity is not binary, it's not all or nothing. Capacity operates along a continuum. Some decisions, of course, are more complicated than others, so you have to parse it out and be context specific. So let's take healthcare decisions, for example. A person may be able to make some decisions, but not others, like consenting to a flu shot versus experimental or risky surgery. Capacity is also not predetermined by a person's diagnosis or IQ. You cannot presume that someone you support doesn't have capacity solely on that basis. Capacity can also ebb and flow. Oops. People may have the capacity to make decisions at some times and not others. So say in the morning or midday after their medications have kicked in, but not in the late afternoon or evening if they're prone to sundowning. And some people may have the capacity to make decisions only if they get help understanding the decision to be made, if they can use their support networks to get answers to questions they may have, or to have information translated into terms that they understand. Capacity can build over time, so decision-making is a muscle that needs to be exercised, or it can grow stale or just not develop in the first place. And I certainly know my decision-making skills have grown over time, and people with disabilities need to have that opportunity as well. Next slide. So here's a list of tools that can help advance supported decision-making. So of course, effective communication is important between supporters and the person with a disability. Using informal or formal supports, peer support, so being able to create connections with people who have shared life experiences and learn how other people have navigated decision-making processes. Using practical experiences and role play and practice. Role play is a big one that I talk about with parents who come to us and they might have transition age youth, and being able to start practicing supported decision-making early on is a great tool. So say sort of sitting down as a group before a big doctor's appointment and sort of playing out how that conversation might go between the doctor, brainstorming what types of questions need to be asked and practicing doing so. Of course, technology, as we all know, that's so important, having the effective technology in place if someone needs communication support and those types of things. And then, of course, supported decision-making agreements is on here as one of those tools.
Yoshida, can you please mute your?
Oh, I'm unmuted. Okay, sorry about that. Using release of information forms is a really good way to just add extra support to supported decision-making agreements, like using HIPAA forms, for example. The Health Insurance Portability and Accountability Act can help ensure if you have a medical supporter that they also have access to your medical records and information. Next slide. So this is a list of the main legal tools for decision-making in DC, and it's ordered from least restrictive at the top to most restrictive on the bottom. So you can see that supported decision-making agreements are the least restrictive of the tools and the least restrictive alternative to guardianship. Next slide. We all use supported decision-making in one way or another, and people with disabilities can use it in a variety of ways too. They can use supports, again, that are informal or formal. They have the option to put their supported decision-making relationship in writing and create a formal agreement. People with disabilities do not have to have a form to use supported decision-making, but it's the best way to clarify the arrangement, and if it's properly done, it is legally enforceable. So there are two options for a formal supported decision-making agreement. One that is for education only, and another that is for multiple areas of life, including finances, healthcare, housing, and really any other area of somebody's life that they want support with. Next slide. So first, we're going to look at educational agreement forms. This one here on the left is the supported decision-making agreement form from DCPS, or DC Public Schools. As you can see, it's very simple, one-page form. It's basically a fancy FERPA, or Family Education and Privacy Act release. It states who the student supporter is and how they will support the student, while emphasizing that the student is the decision maker. This particular agreement form has been around since 2013, when DCPS became the first school district in the nation to formalize supported decision-making. Unfortunately, we still find that schools aren't really using it and are more likely to default to more restrictive options. So I wanted to make sure you know about this information. OSSI, the Office of the State Superintendent of Education, also has its own model supported decision-making agreement form. It's a little longer at 2 pages, but it's the same basic idea as a DCPS form. It's important to remember, of course, that supported decision-making is so much more than a piece of paper. These two forms help because they allow the school to share otherwise confidential information with a student's chosen supporters. But really implementing supported decision-making on the ground takes more than that. Supporters can help the student get ready for meetings ahead of time. They can support IEP or individualized education program goals and objectives that relate to self-determination and building decision-making skills over time. The second option in DC for formally documenting supported decision-making agreements is the statutory supported decision-making agreement form that I previously mentioned. It's a lot of words there, so I'm just going to say statutory form from now on. The Disability Services Reform Amendment Act formally recognized this form. And so who can use this statutory form? The person using the form has to be at least 18 years old, and they have to be signing it voluntarily. If the person has a guardian, it may limit their ability to use the statutory form over the areas of their life for which they have a guardian. So for example, if a person has a healthcare guardian, they may not be able to use a statutory form for healthcare, but they would maybe still be able to use the form for areas outside of healthcare, like finances, education, or housing. The law goes into some detail about who cannot become a formal supporter in a statutory form. And there are two types of restrictions. The first restriction applies to people connected to certain government agencies or providers who are not relatives of the supported person. A formal supporter who is not a relative cannot own or operate any entities that provide disability or healthcare services to the supported person. And they cannot work for a government agency that is financially responsible for the supported person's care. For people receiving DDA services, for example, a formal supporter under a supported decision-making agreement, it cannot be their paid staff or an employee of DDS or DHCF, the Department of Healthcare Finance, unless the supporter is a relative of the person. The big exception here is if the supporter is a relative, and this makes sense because there are a lot of people who work for an agency or provider and also have a loved one that they want to support. The second restriction has to do with illegal or wrongful behavior. So a person cannot become a formal supporter if they have been found by a government agency to have abused, neglected, or exploited the supported person or inflicted harm upon a child, adult, older adult, or person with a disability. Or if they have within the last 7 years been convicted of certain crimes, including sexual offenses or aggravated assault against a child, older adult, or person with a disability, fraud, theft of $1,000 or more, forgery, or extortion. The big exception here is that these background requirements do not apply to the education-supported decision-making agreement forms, like those available from DCPS and OSSI. So now that we know who cannot be a formal supporter, what are the things that people should look for in a supporter? And the law doesn't list specific criteria, but we listed some characteristics that a formal supporter should have. So the supporter should be an adult that the person chooses and trusts, someone who wants to become their supporter and who wants to act in that role, and who wants the person to make their own decisions. This person should be trustworthy and reliable, and who is not likely to hurt or exploit the person in some way. A formal supporter can also serve as a person's agent and power of attorney. And in fact, we often help people create both statutory supported decision-making agreements and powers of attorney. Once the form is completed, then how does it become executed? The language of the agreement has to substantially follow the statutory language unless it's an educational supported decision-making agreement. So the form breaks down into sections, what I call the who, what, and how. So who the supporter will be, what life areas the person wants support with, and how they wish to receive that support. It can say that the person wants support with some types of decisions, but not others. So for example, maybe somebody wants help with medical decisions, but not financial decisions. It's a flexible document that can be crafted around the person's unique needs and preferences. Under DC law, a statutory form has to be signed by the supported person and the supporter. They have to sign it in the presence of either a notary or 2 witnesses, but we always say it's good practice to use both. A person can have more than one supporter, but they have to execute a separate agreement form for each supporter. So for example, if someone decided to have his brother and his girlfriend as formal supporters, he would have to have 2 agreement forms, one for each of them. And when we say sign, that includes a signature by mark. So if a person signs by mark, we typically recommend that it also be notarized. And then you should keep the original statutory form in a safe place and give a copy of it to your formal supporter. You should share copies of the form with other people and organizations that need to know about it. So for example, if your supporter helps you make your own medical decisions, you should give a copy of the agreement to your doctors, any nearby hospitals, and other healthcare providers to let them know that you have a statutory form with a named supporter who helps you with your medical decisions. If you have an attorney or advocate, you might want to give them a copy too. And you don't need to submit the statutory form to a court for approval. The form can also be canceled at any time, and that should be done in writing. It can be canceled by the supporter or the supported person by letting each other know and everybody who has seen the statutory form. The statutory forms also need to include a completed release of information form, like we talked about earlier, just to help facilitate the flow of information and communication. So again, this would be either through a HIPAA form for healthcare and a FERPA form for education. When a person executes a statutory form in conformity with the law, it means they have a right to use this agreement form. If a third party like a bank or medical provider is going to refuse to honor it, they need to have a really compelling reason to do so. Under DC law, they can only refuse to honor it if they have a good reason to believe the person is being abused or exploited, and some people in this situation may have an obligation to report it. This is similar to power of attorney, which can also be rejected by a third party if they suspect abuse or exploitation. And it's important to remember, everyone has the right to make their own choices. All people have the right to make their own decisions and direct their own lives to the maximum of their capabilities. We should support people with disabilities to build capacity to make decisions over time. For many people with disabilities, decision-making is a learned skill. People need the opportunity to practice, and with practice and time, they can develop skills to be more self-reliant and independent. So this is my contact information here, as well as my colleague, Hannah Sidnor-Greenberg. So our phone numbers and emails are available. If anyone has questions, I'm happy to answer them now, or if you want to reach out to me, or if you have people in mind that you think might be interested in learning more about supported decision-making, you can happily send them my way. And Neha, I think I will turn it over to you now.
Thank you, Carrie. And I think we'll take questions in the chat as soon as I just have a couple of comments. I'm going to steal Carrie's slides just to make make a couple of comments here. I do, in terms of, I know Carrie mentioned if you fill out a supported decision-making agreement, the statutory version, you should give it to relevant people, and I would ask that you provide it to your DDS staff or anyone you're working with at DDS, whether it's on the RSA side, your VR counselor, or on the DDA side, maybe your service coordinator. We do try to keep a copy in MCIS for people to be able to access and to provide to your clinicians in case you need that kind of support. Our office, my office, the Office of the General Counsel, has at times gone to bat for families and people we support with the doctor's office, with the banks, to say, we support this person in making their own decisions. We believe it's a valid agreement, and to try to get them to honor it if you run into those difficulties. So it's helpful for us to have a copy uploaded into our databases and files, just in case it's necessary. So I would ask that. Also, I just wanted to point out, sorry, I'm just going to scroll back a second. So Carrie so helpfully kind of gave you the continuum of legal tools for decision-making. And of course, supported decision-making is always where we want to start. I know that in the past, there were some questions in one of the provider forums about how does DDS support supported decision-making. One thing you should know is that the supported decision-making agreement, the statutory version that Carrie mentioned, there's a template on our website available for you. Not only that, obviously, we work with different resources in the community, including Quality Trust, to try to get you assistance you might need in filling those out or filling out powers of attorney. We do have attorneys work here for DDS. We're not allowed to provide legal advice directly to people, but we certainly do provide information through service coordinators on the entire range of legal tools available. And I just wanted to make sure you're aware of that. We also do trainings for those of you in the provider community. There are trainings available every month that I provide, or my colleague Emily Harris provides. We kind of do a two-part series about decision-making supports, including supported decision-making. We discuss that at length, and then all the other alternatives available. So mine is kind of the overview. It's called decision-making. If you look it up online, it's called decision-making and consent. I apologize. A decision-making and consent. It's in TIS every other month of the year. And then my colleague Emily Harris provides one about advanced directives, about planning ahead, including the newer, it's not that new now, but the MOST form and the MOLST form that talk about end-of-life decision-making. So I just wanted you to be aware that those are available to you as providers if you feel like you or anyone in your company needs more training about the legal tools available. And with that, I'd like to see if anyone has questions specifically that we can answer. Haven't seen anything in the chat come in. I'll leave Carrie's information up here. And I'll put, and for me, in terms of our office, you can reach us through your service coordinators. Actually, I'll go ahead and
People could feel free to unmute and ask a question or type a question in the chat.
I'm putting my contact information and Emily's in the chat, especially for providers if you have any issues. Does anyone have questions for us?
Okay, well, I guess that speaks, Carrie and Neha, to how thorough the presentation was. Thank you very much. This is the only thing on our agenda this month. So if people have no other questions, I should I will provide a brief update. The final vote in the first reader vote in the council on the budget happens next week. There was the Facilities and Family Services Committee did meet in the council and have allocated additional funds to DDS in their recommendation to the full council. And those additional funds would allow us to restore about 65% of the reduction that was made regarding clothing allowances and administrative costs for providers. So we will continue to monitor the progress of that. Typically, if the committee has recommended it, it should go all the way through. For people that are unaware, the next step is the council votes twice. The budget then goes to the mayor. The mayor then signs the budget and transmits it to Congress, and then Congress has to approve. So we are moving forward with the budget with those two reductions restored, and we'll keep monitoring and keeping people updated on any changes as they go. If no one else has any questions or anything they'd like to share, then have a good long weekend, folks. For people who are recognizing this Memorial Day for personal family reasons, our thoughts are with you. And we will speak with everyone next month. Thank you very much.